This video is for executors, and specifically, it addresses handling contests and estate disputes. I say this to executors all the time. Being an executor is a thankless job. In most cases, it's unpaid, and they're big shoes to fill. There's a lot to do, a lot of obligations on the executor, and especially in a complex family situation where one person is picked to be the executor over other people. Sometimes there's a little bit of envy and untrust and things like that from the other heirs as to how the estate is being administered by the executor. So, first of all, there's a lot that can be navigated by the executor without it being escalated to a formal legal complaint, meaning an actual filing, an adversarial filing in the probate proceeding itself. Sometimes there's just grumpiness, complaints in passing that are more informal that are made to the executor. These can absolutely be mediated and handled, sometimes with the assistance of an estate planning attorney that's probating the estate to mediate the dispute so it doesn't become more and it doesn't rise to this formal complaint. There are three types of will contests, and I'm going to tell you how to respond to each one. So one is just that the will's not valid. It could be that the formalities of executing the will weren't followed, that there's lack of capacity of the decedent, or there was undue influence from someone over the decedent. So assessing these things include reviewing the will to make sure that the formalities and legal requirements were followed, interviewing witnesses to make sure that there wasn't any undue influence, and maybe consulting medical records just to make sure that there was capacity at the time that the will was signed. Another common will contest is the interpretation of the will itself. And so the issue there could be that the wording is vague or there's poorly drafted language. And so what you should do here is you should go to an attorney and reference case law, state statutes, and examine the circumstances surrounding the will to make sure that everything is okay, or if there is some vagueness or ambiguity in the language, to fill in the gaps with the case law and the statutes and things like that. The third common type of will contest is a dispute over the estate administration. So this can concern concerns over handling assets, sales, or documentation of expenses. What's really important here to understand is that the executor should really keep thorough records and be transparent throughout the whole process of administering the estate. So what happens if someone comes to you with a complaint as to how things are being handled? Don't avoid it. Be responsive, act promptly, and communicate openly with all the parties involved. Address any potential disputes early to prevent escalation to a formal complaint into the proceeding, which I noted, and ensure that everything's being done in a compliant and legal manner and that everything's being documented. If there is a formal dispute filed in the litigation, then this now has become a disputed probate, which unfortunately drastically escalates the cost of probating the estate. But this is something that can definitely be handled with the probate attorney that's working on this. Some probate attorneys don't like to handle disputed probates. Others do. Others do this all the time and handle big disputes. So it's important when using a probate attorney, if there's an actual dispute in the probate, to use a probate attorney that is comfortable handling disputes in the litigation. So big picture here is be transparent, be open, follow the rules, work with an attorney, know what you're doing, and everything should ultimately be okay. Estates are probated all the time, and executors are able to navigate these situations, most of which are smooth, but some of them are a bit rocky. but they're able to navigate it, work through them, and ultimately get them resolved.